name is Spurlin. I'm an attorney in Tifton. I've been asked to speak on behalf of various citizens and taxpayers in Irwin County in opposition to this. I want to speak more to the factual needs to apply the standards that you are required to apply from a legal standpoint and just what your gut feeling might be. Although I agree with most of what has been said by everyone in opposition. First of all, tax revenue generating funding is irrelevant to a zoning analysis and should not even be considered by you. In this, it has nothing to do with your job, which is to apply the standards to the actual facts in the case. The actual facts, as I understand, are minimal. We don't know anything about it. That's the whole application that was filed. 2 pages and 2 exhibits. You don't know the details. Without knowing the facts, you cannot possibly apply the facts accurately to the standards you're required to apply. As Ms. Jessica said, there's a no recommendation because there are no facts to apply to the standards. The purpose of zoning is to protect the whole community against actions of one or few property owners. And your zoning ordinance repeats that over and over and over again. I'm not going to stand up and quote it on it. Section 1.5 says you should protect the needs of the whole community and the whole area over the needs of one property owner. Section 4.11 says 4 purposes of the thing are to protect the agricultural use historic in this county, to maintain and preserve the forest and the rural nature of this land, to retain the traditional ways of life in Irwin County that people chose to live here for. People chose to live here for the way it is, not because they want to live in an urban area with data centers, and to protect the natural resources, the water, the rivers, and the wetlands. And the zoning standards clearly say, if not specifically permitted, it's prohibited. Now, how do you apply your standards to the facts? We don't know the facts. The gentleman comes up here and says, well, we promised to do this, and we promised to do that, and we promised to do that. And he says, there's going to be an ordinance passed. Well, there's no ordinance today. So my input on that would be wait until there's an ordinance, wait until there's standards, and wait till they submit specific facts and circumstances so that it can be controlled. Otherwise, if you just randomly say you can do a data center, what size, how much water, how much electricity, how much details, you have no specifics. Real quickly, your standards are set forth in page 80 of your zoning ordinance. And they say you've got to consider all these standards as applied to the facts. But we have no facts. We don't know size, we don't know water analysis, we don't have studies of that, we don't know how much electricity will be used, we don't know how it will apply, we don't know if it will affect cost. From a legal standpoint, you present facts, and then the judge applies facts to standards. And they have given you no facts, they've given you variables.
Thank you.